On behalf of Equinix, I'd like to present Gareth Bridges, from eLaw, Alison Stanfield, from Symantec, Sean Capel, and from Baker McKenzie, Patrick Fair. And I'll pass you on to Gareth.
Okay. Thank you very much, George. Okay, well, good morning, everybody. Thank you very much for making the effort to get here so early, especially after last night. I think there's probably quite a lot of people I didn't expect to see here. So, yeah, anyway, as George said, I'm Gareth Bridges. I'm from Equinix. And we're a data center company. So, you know, I will go into a little bit about why would a data center company be so involved in sponsoring an event aimed at the legal sector. So we'll come on to that later. But firstly, I'll introduce the panelists. I think George just did it, but you know, we've got a very diverse group of people here. We've got Alison, who's the CEO from eLaw. And she's got very rich experience with things like litigation support, electronic discovery, those kind of things. So she'll be able to kind of share a lot of her experience, her background in customer engagements on this kind of thing. We've got Marco from Levens, and he's the IT director there, and he's been very, very instrumental in moving a lot of their core technology functions into the cloud. So where I think a lot of organizations have been very risk adverse, you know, and haven't really felt the confidence to do that. You know, he's actually been through a lot of the objections and the kind of discussions that how you can do this responsibly. We've got Patrick. Patrick Fair from Baker McKenzie. He's very much focused for the purpose of this panel on, he's a subject matter expert as far as the legislation is concerned. So things like the Australian privacy principles, data sovereignty. So what are the implications of putting data into the cloud? What happens if it moves between boundaries and this kind of thing? He'll be able to provide expertise on that. And we've got Sean Capel from Symantec, who is the technology director for Australia and New Zealand. And he'll be able to share a lot of insight, a lot of customer examples about how organizations are able to use technology to provide automation. And essentially, by having those controls in place, allow you to actually do a lot more with the data than if you didn't have any security. So Sean will be able to kind of help with that. So as far as data center companies are concerned, you could say it's a very dry topic. I mean, it's lots of power, lots of air conditioning, very noisy, uncomfortable environment, which is kind of something I'm not particularly interested in. But what's more interesting is actually what goes on inside our data centers. Okay, so yes, we've got all of the things, you know, the security, the network operations centers, all of these things exist, and you know, this is kind of what we consider the most fundamental part of delivering a kind of purpose-built data center. But how does this relate to law firms? Okay, it's basically inside our data centers, we have what we call ecosystems. So if we look at something like the finance sector, pretty much all the major banks, and we're talking like 90% of the banks, will have key parts of their equipment inside our data center, and this allows them to do things like high-frequency trading. So if you're going to do things like currency trading, stock trading, those kind of things, it's very easy for them to have you know, basically access to all the buyers and sellers inside our data center. So everybody that they want to trade with are already inside our data center. So they can actually then say, I'm going to take an instruction from somebody, I want to exchange this much money, and then they can start shopping around to get better price, squeeze better margins, and this is how they make money. But by having it all under one roof, you have direct access, so you can completely skip the internet. So what you have is very, very secure links, to literally just a piece of cable. You have very fast links, unlimited bandwidth, low latency. So you have this whole environment where things can happen. Similarly for advertising, like the adverts that you see online, all of this stuff is brokered inside of our facilities. The other thing as well is we provide a lot of locations. So basically we're a global company, and pretty much where every organization is looking to expand, we already have presence in those locations. So I speak to people last week in China. They want to set up their eDiscovery practice in China. Nobody in China takes them seriously because they haven't got any facilities. So they can say, no problem, we can just expand. We can take some space inside the Equinix data center, all certified by the local legislation in China. meets all the international standards. We've got English-speaking staff. So for them, it makes it very, very easy for them to kind of expand their operations across the globe. And lastly, we have a very, very rich base of networks and cloud providers. So again, as you start to want to do business with people outside of Australia, I mean, I'm based in Hong Kong. Our Hong Kong data center's got 250 network providers coming straight into Hong Kong. So if you want to kind of host your systems in Hong Kong, Telstra comes straight in, Optus straight into our data center. All the US ones, AT&T, Verizon, everybody's coming straight into our network. So again, this gives you a very, very stable and scalable environment for you to be able to host your system. So in fact, Symantec, eLaw, many organizations are hosting their environment inside our data center. So that's kind of just a little bit of background. I'll try not to keep it too boring. And then I think we can talk more about what really we came here to talk about is the kind of data privacy, information security, and cloud computing. I think these are the kind of the three, I guess, topics that I decided that, this is what I think would be most interesting to people. I wanted to have separate segments so that we could say, okay, let's talk about cloud computing, let's talk about security. But in fact, as I was going through the preparation, the more I look at it, the more I found that you can't talk about cloud computing without talking about security, without talking about information privacy. Basically everything is so intricately related that I can't prepare it in a way that we're going to do that. So I think what will happen is we'll start to move around the topics. And I mean, before we get started, I mean, is there anybody who would have any questions about this? I mean, if we're talking about moving information into the cloud, is there anything that's kind of front of mind for anybody that you can't do this because of, what happens if the company goes bust, or what happens if this information is stored out? I mean, if we can take some questions to start with, we can get going with those. Otherwise, we'll move on. Okay, no questions. Good. All right. So I mean, okay, with regard to cloud computing, I mean, let's. Who should we talk to first? Let's talk to Sean. You're working with, as a provider of cloud computing, and also as an advisor to organizations who are considering to move to the cloud. How are you kind of helping customers assess what's a reasonable application? How should this be moved into the cloud? What stages of readiness are organizations at? For example, if people are just going to move their internet mail, their antivirus, their anti-spam into the cloud, or are they moving core applications in that are close to their business? I mean, how are you seeing this at the moment with your customers?
Yeah, so I think, thanks, Gareth. From our view, we've actually seen quite a big shift in the last year or so, where a lot of people originally started the conversation around moving to the cloud is actually a security risk, and therefore I'm not comfortable with doing that. So we would talk a lot about around that area. But we've actually seen a big shift in the last year or so where organizations are starting to think, well, actually the move to the cloud will actually increase my security. And that's the big change in the conversation. And it sounds like an odd thing to say, but I'll talk it through why we're seeing that, is that we did some research, and we published yearly research around a lot of the big data breaches that happen out there with information loss. And we're talking about this earlier this morning. 60% of all data breaches that happened last year actually happened at small to medium-sized organizations, not the big, large corporate organizations. And people start to think, if I'm thinking about the risk of my information, it's always the big companies we should worry about, the big banks, the big organizations. But the reality is that the cyber hackers out there, the people who are trying to attack and steal this information, will quite often target the small to medium-sized organizations for two reasons. One, they quite often hold just as much interesting information as some of the big organizations, that they, identity theft information they can steal and reuse. But because all of our businesses are so interconnected, that they find that through supply chain, if I attack the smaller organization, I can then get to the big organization. So we all would have, probably read around Christmas time, there was a large retailer in the US that had a major breach. When you dig into that large retailer itself actually wasn't breached. They breached one of their supply chain people and then got in through to the organization there. So going back to what I was saying, why the shift to the cloud can actually increase in security is those small to medium-sized organizations are a target. They're increasingly a larger target. It was the previous year was about 50% were small to medium, now it's 60%. But the problem with those small to medium-sized organizations, the challenge that they face is they can't afford to employ the high-end security knowledge that they need to protect and manage their information. So that's one challenge. Two, they often don't have the infrastructure or the money to spend on building out the systems that they need to secure and protect that information as well. So by shifting to a cloud provider, where a cloud provider's reputation, brand and everything survives on how they protect people's information. So it's a shared risk. So if a small to medium-sized organisation moves to a reputable cloud provider, quite often that cloud provider actually will have better security systems in place, higher security talent to manage and look after that information as well. So there's definitely been, from our end, that big sort of shift in actually the cloud's a positive thing, and all the other great things that come with it. My data becomes more flexible, more portable, etc. But there is actually a benefit from a security point of view if you move to the right cloud provider, which is a whole different conversation as well around analysing and understanding what cloud provider I should deal with as well.
Yeah, thank you, Sean. So Marco, I mean, you've moved numerous of your core systems into the cloud. So I mean, Sean was just saying that it's actually somehow more secure to put this information into the cloud. So when we compare this to say, well, look, I've got all of these on-premise systems at the moment, and I guess there's a certain amount of feeding and watering these systems need patching and so forth. I mean, how are you finding the advantages of speaking to a cloud provider who's more focused on this? I mean, what is the kind of major differences that you've experienced? I mean, and I guess how do you use that to kind of overcome the objections from your management that basically cloud's not secure, and how do you kind of give them the assurances that this is something that is not completely irresponsible of you to put it out there and so forth?
Okay, there's quite a few sort of questions in that.
Take it where you want, and I'll come back to the rest.
I'll start with the security, and I certainly can completely agree with Sean, and that's what we looked at. So Lavin Legal in Perth, relatively, I mean, it's certainly small by international standards. I think even an Australia-wide law firm would still be considered a small organisation by world standards. No, we cannot afford the security infrastructure, the security people, the processes that the large cloud-based suppliers can. That's a fact. We looked at these, so we're using a number of cloud-based systems, but I understand the first law firm in Australasia to move to a cloud-based document management system, certainly a core system for law firms. Documents, I mean, it's the lifeblood of a law firm. Looking at our security as opposed to the security that could be provided externally, and spoken to many security organisations, the security that is provided externally is better than what we can provide internally. So that's the first thing. Now, so to try and answer some of the other questions, before moving systems to the cloud, and I might add we have been using eLaw for litigation support, cloud-based for years. Litigation support, litigation, again, we're a relatively small firm. We might get some large litigation, then things go quiet, then we get a couple of really large matters. And I can't sort of scale up and scale down that quickly. It's both from staff and it's both infrastructure. So there's some other obvious business reasons to use something like eLaw for litigation support. We've been using outsourced payroll for many years. Again, it was just from I didn't want any of my internal staff to have access to payroll information, so there's things like that. Document management, started looking at that, and also time capture. So we use Net Documents for document management. We use Recoup for time capture. One's Manchester data centres in the UK. Net Documents is in the US. Before moving to these systems, obviously I had to convince myself that it was a safe thing to do. The firm is, the risk for the firm is their data, their information. The risk for me, from an operational point of view, is I had to know that operations were not going to be affected. I mean, that's my job on the line, it's that simple. So started looking at, and I had to convince myself of the, to make sure that I was comfortable in moving. I did like everybody else, all the fears. There's the security, the privacy, the data sovereignty, what happens if the internet link goes down, what about integration? There's just all the things that everybody would ask. So I went through, looked at those with an open mind, saw that security actually, instead of being a negative, turned out to be a positive. Integration with other systems turned out to be a positive rather than a negative. looked through each of the fears. There's a lot of fears on the market. Looked at the concerns, as you would do with an on-premise system. I mean, if any reasonable person, if you're putting a new system, is going to just go through the stages. So do it with an open mind. Once I'd convinced myself and pretty much prepared myself for the questions that were going to be asked by senior management, and they were the things that I just mentioned and a couple more. So clearly the strategy for me was to anticipate every concern that anyone in the business was going to raise, make sure that I was convinced myself, make sure I'd done sufficient research, so when those concerns came to the front, I was able to address them. Yeah. And I'll be honest, that I still have a very senior partner within the firm who is completely against anything cloud-based and is constantly sort of trying to find ways to get at me. But again, yes, I know it's being taped. I won't mention the name. That's the reality. You're going to face that within your organisations. But go through the process diligently. And for me, certainly, I've found that rather than being risks, you look at risk versus reward. Again, any business decision, it's risk versus reward. The rewards far outweigh the risks.
Thank you. Okay, so I mean, when we start to look at this as well from the perspective of cloud, is definitely something which is providing a much more centralised platform, and I guess to some extent having, being built with interconnectivity in mind. Okay, I mean, Alison, you're looking at eDiscovery, so I guess you're involved in things like collections and this kind of thing. So when you're dealing with organisations to, basically you've been asked to go and collate all this information from different places. Have you found that the cloud somehow introduces lots of red tape for you? Has it introduced complexity, or does some kind of standardized interface and environment, centralized model, does that make things easier? I mean, how is this in terms of your customers and their move to the cloud and everything? How does this affect your business?
Well, firstly, can I say that, as Marco said, we have been hosting electronic discovery software in the cloud for a number of years, and I think that was a major shift for law firms to get their heads around. I think even, say, 5 years ago, a lot of law firms weren't comfortable allowing information to go outside the law firm itself, whereas now most data is actually hosted external to the law firm, and these days it's not even an issue. So I think there's been a shift there for a start. Secondly, with respect to collection, obviously if you're getting information from the cloud, then it tends to be a little more organised than if it's simply stored on servers within an organisation, simply because you are paying for every gigabyte that's hosted. You need to know what's there. There tends to be a bit more thought around getting the information there in the first place and then managing it moving forward. From a collection point of view, you do need to work a lot more closely with the client, because getting access to that requires user IDs and passwords and so on, rather than simply collecting off a server or desktops or laptops, that sort of thing. Obviously, you can't get all of the information you would have got from a forensic collection in the past, such as information from the unallocated space. Excuse me, I think my cold's finally kicking in this morning. The late night didn't help. And so, yes, I think certainly cloud is changing, is a game changer, but I can only see positives in that.
Okay, so lastly, Patrick, we're seeing organisations. I mean, there's definitely there are clear advantages to moving information into the cloud. But I guess to some extent, I mean, in Australia we've got very kind of clear guidelines about kind of data privacy, data sovereignty. I mean, by moving, for example, stuff to Salesforce.com and this kind of thing, how do people do this in a way that kind of means that they're not going to put this data into other jurisdictions, and what are the kind of ramifications of doing that? I mean, are we going to see that people have to repatriate data, or is it okay to just keep copies of it here? I mean, how do kind of organizations overcome these things where we have, basically cloud that is, maybe the customer doesn't even know where this data is being, is this foolhardy or?
Sure. Well, let me answer that question in two parts, I think. I think there's a question of data sovereignty, which is a policy and strategic question that's a little more amorphous. And then there's the literal requirements of the Australian law that you need to comply with. So let me talk about the literal requirements first, because that's sort of more practical and down to earth for the sort of topic that we're talking about. Surprisingly, we don't have a law that says you must keep information on shore. The closest we've got is that you've got to keep your company register at the registered office, and I think it's got to be accessible from the registered office, so potentially you could put it out in the cloud. You've got to have access to the records that you need to keep. The sorts of situations where an actual data sovereign, an obligation to keep information locally is imposed. I think there is some state law that talks about having an H&O policy that needs to be at your office. And if you're a telco and you're dealing with the Commonwealth and you're doing interception, they may well impose on you an obligation to maintain records onshore and to make sure that information about interception that takes place in Australia is not disclosed overseas. But absent that, there's no overriding obligation to keep information onshore. So the two relevant laws that come up the most are APP 8 from the Australian Privacy Act and APP 11. Now, APP 11 came in force on the 12th of March, and people are still getting used to it. But one of the interesting, this is the Australian privacy principle that says that if you hold personal information, you must keep it secure and protect it from access and modification. Now, this is new because it used to be that you weren't subject to the Privacy Act unless you collected the information and made a record, but now you just have to hold the information and you're subject to this obligation to keep it secure. And your security has to be at a reasonable standard according to the personal information that you hold. And that sets a benchmark. It binds everybody in the chain, whether you're actually the party collecting it or the party holding it or the party processing it. And there are guidelines from the Commissioner that says those security obligations need to be proportionate. And so if you're dealing with other people's personal information and you have a data breach, that's where the Privacy Commissioner will go. They'll say, right, did you take reasonable steps to protect this personal information? We don't have a mandatory data breach notification law, so that's the test. If you fail that test, the maximum fine under the Privacy Act now is $1.7 million, and you can be subject to mandatory orders. It's a serious problem. The second one, which is perhaps more relevant to what Alison was saying, is APP 8, which is about transborder data flow. Now, the old privacy law said that you could send information offshore, that you could, you weren't allowed to transfer information offshore unless you met certain conditions. Well, many people in Australia said, well, that's good. We'll store the data in Australia and we'll give the business processing outsourcing operation in Manila web access. So we haven't transferred the data, we've just let them use it. And that was pretty acceptable methodology for getting around APP 9 it was NPP 9. But the new one says that you won't disclose information offshore unless you've taken reasonable steps to ensure that the recipient does not breach Australian privacy law. Now, this creates serious problems for cloud providers because if you're a cloud provider and you receive personal information and the customer says, look, I want you to abide by the Privacy Act, then, well, you can't, because you're supposed to send collection notifications to the data subjects when you take on their personal information. You're supposed to have an Australian there's all sorts of obligations that you can't meet as a cloud provider. Now, fortunately, the guidance that the Commission has provided on APP 8 makes a distinction. And it's a very critical distinction which is not fully understood at the moment, and that is that disclosure means releasing information from your releasing the information to a third party and from your subsequent control. So the guidance says that you can give information to a cloud service provider, providing they are not allowed to make independent use of it, and you've taken certain steps which are specified in the guidance. Those steps being that they must keep it secure, you must remain in effective control, they can't use it for any other purpose, their contractors must be subject to similar rules. And so the critical thing is to make sure that you've pushed the cloud providers' access to your information into this category of use rather than disclosure. And if you do that, you completely can change the profile of the risk of having this information with a cloud provider. Because if you disclose it to them, then any data breach is immediately your problem. There's Section 16C of the Act says that a data breach offshore by somebody who's received disclosure, you're strictly liable for that as if it happened in Australia. But if you didn't disclose it, you gave a use. Then, so that's the regulatory framework. Now, I don't want to keep talking, but shall I say something about data sovereignty as well?
Yeah, maybe.
Sure.
Yep.
So this data sovereignty issue is very complex. I think the first thing to think about is that there is no question that the data is subject to the law of the place where it's stored. Right? So the minute you put it offshore, it's in another jurisdiction, it's subject to the law in that jurisdiction. And the critical thing to note about that is if the government of that jurisdiction gives their version of ASIO a warrant, and they turn up at the data centre and they say, this is a gag order, I want to see what's stored there, then subject to technical limitations and the practicality of that, they can take it and you may never find out about it. So that's the worst case scenario, right? You've got it offshore, somebody else can access it. So the real problem is how real is that as a commercial problem for people wanting to put information offshore? And how concerned should we be about it? So the first thing to say, sort of in judging that, is that Australia, like a lot of countries around the world, is a signatory to a treaty which has led us to enact the Mutual Assistance in Criminal Matters Act. And if a foreign law enforcement body wants to get information to any data by any Australian, they can ring up the federal police, and if they're a treaty signatory, they'll get access to it locally. So on criminal matters, putting it offshore really doesn't make a difference. Then there's a question of, well, what about the fact that I've given it to a third party and they're in another jurisdiction? Does that cause me a problem? Well, look, our systems locally are very, widely outsourced, and the question of whether or not having it offshore creates a new risk really depends on the status of the person you're giving it to, the strength of your contract, what you know about their systems. It's almost a due diligence question. Then there's this question about enforcement. So can I, if I've lost my data in that jurisdiction, supposing it's, say, in India, and I want to use the legal system to try and get the data back, is that going to be possible? And that again comes down to, well, is there a real risk of it being lost and in that centre, and how big is that risk? But that's a factor that people consider. And then the final one that I think people are really concerned about is this sovereign risk question. So many of you would have seen the report. It certainly had me ringing our CIO at Baker McKenzie that Mayor Brown in Chicago had their systems penetrated by the Australian ASIO when monitoring trade talks with the US because they were advising the Indonesian government about trade matters. Now, Baker McKenzie's head office is in Chicago and Mayor Brown are just down the road, and I'm going, wait a second. So there is certainly an issue that the security agencies in different companies can do interception and can get access to your information. My question is, how different is it when it's in the cloud offshore and when it's held locally? For example, if you've read the Mandiant report about the Chinese Special Army Division that is seeking to attack US intellectual property assets around the globe, and there was a new one by a company called CloudStrike only last week identifying another part of the Chinese army. Those attacks are not specific to cloud outsourcing, and they're not specific to whether you've got your information here or somewhere else. I think it does sort of raise a question though, like if you have the accounts of Rio Tinto or BHP in your bank, or you have sort of major client strategic information in your systems, you probably don't want that hosted in a data center in the People's Republic of China. And that might be a question that you should be asking when looking at the information. It means you need to look at what information you've got and evaluate the risk relative to that information.
Yeah, very good points, very good points. So I mean, Sean, with regard to this, I mean, as people start to consider this, they're kind of looking, don't put your information in places where, you've evaluated the government and their likelihood of wanting to access that information. I think also it's kind of this more centralized approach, this open approach, it does kind of introduce much more surfaces where people are able to attack your information, how they can break into it. So yes, you could have all the security you want in the cloud. But ultimately, as people say, there's well, I thought there were two types of companies: those who've been breached and those who don't know they've been breached. But I mean, you said there's three. So how do people kind of prepare for this? I mean, ultimately, if you're the board of a company, you understand all these decisions. You understand, well, look, yep, there's definitely a risk in putting it in the cloud. There's a risk in not putting it in the cloud. But ultimately, I just want to know: is my data secure? How's my reputation? Am I going to be able to protect it? What do you see? What are the kind of biggest oversights you've witnessed with regard to this?
Yeah. So, well, a couple of things. Stepping back to that first point you made, and I don't mean this to sound alarmist in any way, but the point you're talking about, the types of organisations, and we referred to this morning, is there's organisations that have been breached, those that will be breached, and the third is those who have been breached and don't know it, right? The average amount of time between when an organisation has actually been breached by a third party and then they find out about it is about 245 days, right? So most hackers are inside organisations for 240 odd days before the company realises it. And 2/3 of the time it's an external company that tells them that they've been breached. So, and then when you look at that in another way, it's an unfair game, security as a whole. So if you're a betting person, and I said, okay, in this competition, you can bet on Team A or Team B. And Team A only has to be right once to win the competition. And Team B has to be right 100% of the time to win the competition. And Team A doesn't have to listen to the referee. They can do whatever they want. Who are you going to bet on, Team A or Team B, right? So everyone's saying Team A. Well, Team A is the hackers, right? That's the world. They only have to be right once to get inside your organisation. For us all protecting it, we must be right 100% of the time. So based on that, let's assume the fact, and then that most organisations have or will be breached, is that you're going to lose this game at some stage. Okay, so the shift, I think, around security, and we start talking about our risk of where do we put our information, do we put it in different countries, and that is you almost need to take the position when you're looking at advising people around the protection of their information is assume that you are going to be breached, and when we start talking about resilience is that when you are breached, how do you actually respond to that? And that's what becomes more important, okay? So that's the big shift, I think, in the threat landscape over the last couple of years. And, we start seeing all these things that come out from the Snowden files around the capabilities of foreign governments to tap in and listen to information. And when you dig into it, there's things like, they've been selling monitor cables that plug from your PC and shit that's got little chips in it so they can park with the van across the road and listen, see everything that's coming up on your monitoring screen, right? All that data that was leaked is 2 years old. Can you imagine the advances that have happened in the last 2 years? So whatever you're hearing back then, right, and we're hearing about today is probably quite primitive to the capabilities of today. Yeah. So the risk is massive in either way, but where we need to focus on is, it's all going down to what Patrick was saying is, what, for you as an organisation, what is the likelihood of that being a risk to you? Okay, and we're starting to get people to start figuring out, when you look at your information, stop worrying about whether you're putting it in the cloud, whether you're putting it on premises, or you're putting it behind a firewall. There is no perimeter anymore, okay? We have our mobile devices, some of it's in the cloud, some of it's in here. And start actually figuring out, defining policies around a type of information and make sure that policy follows the information wherever it goes. So if you're going to go to a third-party outsourcer or a cloud provider and you have strict requirements of how a piece of information should be looked after, not just from a security point of view, from an availability point of view as well, and how that's stored and managed and the time it's stored and managed for as well. And you just need to make sure that you negotiate with those cloud providers that when you shift that information from point A to P, that responsibility follows with it, which goes very much in line with what Patrick was saying around his as well, in that sort of position. So, look, I think from the security point of view, I don't mean to leave that scary sort of point that all your data has been breached, but the reality is that a large amount of information, if anyone wants it, anyone can get access to it. The right people, the right resources can get access to it. There's a highly talented people out there. So you've got to be prepared to how to respond when something goes wrong. And I'll give some really positive examples around this. So has anyone ever, and I'll use a brand name because they're quite public about it, has anyone ever heard of the tool Evernote? It's a note-taking tool. Okay, so it's a fantastic tool, right? So it's a note-taking tool. It's cross-platform. Evernote had a major data breach last year, right? And when they had that data breach, they sent a really interesting report a month later. Their customer take-up of their service increased by 40% within the first month of them announcing that data breach, right? Sounds odd. They actually got more customers moved to their platform. What actually happened is when they were breached, within 12 hours of being breached, they had a response plan in place. They reached out to their customers. They told them what went wrong. They told them how they protected the information. They went through the layers of why the customer shouldn't be concerned, right? They actually turned a negative into a positive in a really powerful way, and people's confidence in that brand lifted, right? So they had their evacuation plan in place before the building burnt down. A lot of organisations are making it up when the building's burning down. It's the wrong time to do it. So that goes to that resilience conversation. Understand the things that you need to do when you get breached, because it's most likely you will. And just one final example on that. You know, we've all heard about the breaches of the information from NSA a year or so ago. And I was at a security conference in the US, and one of the people who was involved in that and who works for the NSA actually got up and presented. And he said this amazing fact. He said, you know, before we went to the public and announced that we had been breached, you know, that Sony had taken all this information, we knew about 6 to 8 weeks before that, but we knew we had to tell the public because it was going to get out there. He said the 6 to 8 week delay, one of the major reasons of that delay was that we knew we needed to work with an external PR firm to control the message to the market. We had no PR firm that had gone through national security vetting that we could work with. It took us 6 weeks to do that. They should have had that plan in place beforehand, right? So that's just one simple example of being prepared for when the scenario actually happens.
Marco, do you have something? Yeah, thank you, Sean.
Just from a practical sort of point of view, so from a law firm that's been through this and had to deal and consider with these sorts of concerns. Around the, I looked at and thought, as has been said, if a serious player, whether it's a government-sponsored organisation, China, I've been speaking to some security consultants who do work for the UK Secret Service. They actually claim that a lot of the propaganda against the claims against the Chinese, the Americans are actually, they do more work in that area than the Chinese do, but they're very happy to be pushing it across onto the Chinese. Apparently in the UK, it's sort of legislated their security services can't use the information that they collect for sort of business reasons to sort of further the business interest of the country. But I understand in the US and certainly China and other countries that's not the case.
Including Australia. So there's a provision the Attorney General can access information for in the interests of Australia. It's a very broad provision.
Exactly. So looking at it, and again looking at if serious players wanted to get to your data, it really doesn't matter whether it's in the cloud, whether it's on premise, whether it's in Australia, wherever it is. So that's just concern. We don't deal with terrorist organisations as clients. We don't deal with criminal organisations as clients. Certainly not that we know of, and we wouldn't want to. So again, looking at the risks in a normal business environment. The information that we store, government agencies should not be taking that and certainly not leaking it elsewhere. The risks are more from the sort of the hackers. And the hackers generally have a better chance to get into your on-premise data than they do into the cloud data. I worked on the premise that, again, yes, it's not a matter of if you get breached, it's when you get breached. So when you get breached, it's a matter of how do you limit the damage that can be done. And I mean, internally there's still things, there's a lot of things internally we have to do to limit the damage, whether it's just limiting the access to the system administrators' passwords, what servers they can get to. There's a bunch of things you can do internally. But again, looking at the cloud-based systems, the security, whether it's physical security, whether it's all the other things that are already talked about, they can generally provide better security. I say generally, you certainly want to look at the countries. So we felt comfortable dealing with the US despite the Patriot Act. We felt comfortable dealing with the UK, so data centres in the UK and the US. Going through the contracts, I was sort of going through that about 18 months ago. I was provided a summary of the Privacy Amendment Act. Had a look to see, well, what sort of things needed to go into the contract, so to satisfy our obligations under the Australian proposed privacy laws at the time. And I understand, I think it was APP 8.1 provides a little bit of protection around. A lot of people think that you have to disclose if you store your information overseas. You don't necessarily have to disclose it. And
yep. That's the point I was making. It's the obligation in APP8 is if you want to disclose overseas, you have to take reasonable steps to ensure that the overseas recipient, does not breach the APPs. So there's two important limitations in there. One is you don't need to require the cloud provider to comply with the APPs. You just need to impose obligations which facilitate your compliance, i.e. that you maintain effective control, that they can't use the data for another purpose. And so long as you restrict it so that they don't actually breach the APPs, which you can do in a practical way, you're compliant. And the second thing is if you impose those restrictions very heavily, then the guidance from the Privacy Commissioner is that that's not a disclosure at all, it's a use. And if you've got that right, then you've got yourself out of liability for data breach offshore. So, but that you wouldn't have seen when you looked at the summary back then, because this is guidance the Commissioner released about 2-3 weeks before the actual law became law.
Just a question, Marco, following on from what you said, as I know we've talked about this before, that it seems that you've put a lot of consideration into all the what-ifs by moving your information into the cloud. And I guess the question is, well, what's the worst case scenario? If your data is breached, something happens to it, I mean, ultimately, I would imagine you've got a full backup of everything so that, that is your fallback position. Do you want to just perhaps let the audience know what you've done there?
Absolutely. I mean, that was one of the things on my list at the beginning, looking at cloud-based systems. So I'll use the document management system as an example. No, I was not prepared to take the risk to have all of our documents and emails stored overseas, and I didn't have a copy of them. That particular organisation does provide what they call a local document server, and it's a mirror of the data, low-cost storage, low-cost sort of processing, but we have it. So worst case scenario, all of the internet out of Australia get broken. It's going to be cause a lot of other issues to Australia. But if that happened, if this organisation that has 1,400 law firms, mostly in the US, some 2,500 user law firms, if that organisation went bust, and again, obviously a certain amount of due diligence, they own their own hardware in different data centres, different geological regions. So another benefit of cloud computing I see is me not having to worry about the disaster recovery. It's a big cost in having a DR site. Everybody knows the amount of effort and money that goes into that. But just making sure, I mean, that was just another thing to make sure that if the absolute worst happened, we have access to these documents. We have control over these documents. If there were some contractual issues with that organisation, they refused to give us our data. Yes, we could go after them in the courts. Well, that's going to take too long anyway, and no one's going to want to do that. Just going back to a point Sean made about reputation, it's not just around security. Cloud-based suppliers, that is their business. Their whole that's it. They're not doing anything else. So a document management system cloud-based supplier, if there are any data breaches, if there are any other issues, they don't want to have contractual issues themselves. But again, for a point of protection, yes, you have a backup, and that was a critical thing for me.
So in terms of things like contractual things, I mean, Sean was saying that it's important that you have these policies defined, you have these plans defined, and more importantly that when you do have policies associated with data, that they follow the data wherever that data goes. So I mean, with Alison, with your business, I mean, you're engaging with organisations. They're entrusting a lot of their most sensitive information to you. I mean, if this information kind of gets outside, it could be catastrophic. It damages their reputation. So, I mean, how do you manage this with them? Do you adhere to the same standards as them? Do you demonstrate these are your processes and this is how you're going to accommodate their security requirements? What do you generally do with your platform?
I mean, it depends on the matter. I mean, most matters that we deal with, as I think Sean mentioned before, it's a question of how sensitive is the information. And generally, in the matters we deal with, the sensitivity is not high. I mean, sure, it would be high for the parties involved in a litigation, but really, if there was a data breach, then that really is our reputation. Yeah, so I need to ensure that I have the appropriate security measures in place, but within reason. You know, we're not dealing with highly sensitive military information or things like that. So, you know, it's a reasonable level, I guess, within what, you know, my business can afford, but also within the realm of what my reputation can afford if something happened. I mean, it depends. I mean, you know, we've worked on Royal Commissions previously where I've had the commissioners sit down and say, you know, I don't want a breach because if that happens and ends up on the front page of the Fin Review, then your head's on the chopping block. So, you know, in that case, we ensured that, and that was a long time ago, and we didn't have the cloud provisions that we have now. But, you know, you look at each case in isolation and then put appropriate security measures in terms of what the client wants and, you know, what we require. And so it does depend on you know, on a case-by-case basis.
Okay. So Sean, I mean, you...
Sorry, we've got a question.
Okay, question? Okay.
I just want to ask a question mainly directed towards Gareth and Patrick. I come from a law enforcement agency. I come from the Independent Commission Against Corruption. Now, Gareth was talking about companies, cloud companies having evacuation policies so that they can move in quickly and respond to limit the damage that's been done. But if I serve Patrick with a notice under my Act, requiring him to produce all information in relation to a particular client at Baker and McKenzie, all information that's in his possession or his control, all the information that he has in Hong Kong, in the cloud, is in his control. And he has to provide it to me, even though it's outside the jurisdiction.
Yeah.
Now, there's a couple of, I just wondered, firstly, is that consistent with your understanding, Patrick, that even though it's outside the jurisdiction, it's within your control?
Absolutely. I mean, that's consistent broadly. There's US case law on this. I mean, it's not just law enforcement agencies, it's the civil courts. If you get a subpoena or you've got to do production, there's no argument, oh, this is what we've got on shore. You've got to deal with anything you've got access to. Came up in the BT case. That was a major part of that the dispute about what information BT had kept offshore and hadn't disclosed in their litigation. There's US law about you know, information held in Swiss banks and whether or not the company forced to disclose in the US could disclose because the Swiss banking law said they couldn't. I think in that case they were able to say, no, we can't do it because we'd be in breach of the law in another jurisdiction. But if it is in your control, then you've got to disclose it. So it doesn't make any difference where you've stored it. And I think that is an important part of the context.
Okay, what if it's in your control, but there is legislation of another country that's preventing its disclosure to a government? Say the Hong Kong government says, no, you can't have that information.
Yeah, I can't remember the name of the case off the top of my head, but there is a US case where exactly that came up, and it's the counterpoint to some earlier case law about being forced to disclose in the jurisdiction. And I think on appeal, in the case I have in mind anyway, the applicant was not required to breach French law, Swiss law in order to make the disclosure. You know, I don't know what an Australian court would do. And in that particular case, the important thing about it was that it was the plaintiff who was trying to prosecute, and the fact that they wouldn't make full disclosure and couldn't make full disclosure actually disadvantaged them in the eyes of the court. And so, you know, it can create an issue of that kind, but it's an unusual thing to find that, well, you know, I'd be very surprised if in the majority of cases where things are held in the cloud, there was a local law that said, wait, you can't get your own information back for the purposes of meeting a subpoena or an order from there.
Be used as a strategy for people to protect their information. You want to work with an organisation that has its cloud in a country that prohibits the release of information at the direction of external governments. And that would give your client safety, that you and your client would then be protected against the government of the country that you work in, because you wouldn't have to disclose information that's held in a cloud in Hong Kong or whatever country is regulating the use of the information stored in their country.
Maybe I think we can move this on a bit. I think in terms of that type of thing, I guess it's going to come down to, as Sean mentioned, having those policies in place. So if you know that you're going to be dealing with organizations that are sensitive about that type of thing, you probably want to make sure that you have a suitable strategy in place for where you're going to locate that data. There's actually a very interesting white paper written by FTI, one of the vendors here today. I think it's called something like Catch-22, and it's about how basically sometimes you're going to have exactly this situation where you've got a company or an organization who's storing data in this country, storing data in that country, and it's essentially which government do you want to upset the least? And basically, I'm not allowed to disclose it because of the US legislation, but the European legislation is making me disclose it, and it's kind of how do you balance that off? Who do you upset, and what is the implications of doing that? So in balancing the risk around that. So I think probably afterwards I'll introduce you to some of the guys at FTI, and they can probably.
I'm just interested in how strategically people could exploit the cloud to defeat accountability and scrutiny that they're currently under.
I think it's generally kind of understood that I'm not an expert in this by any stretch of the imagination, but you're going to outsource to certain tasks, but you're never outsourcing your responsibility. So regardless of where you and how you decide to store that data, it's always going to be you're the one that's accountable. Or you're the organization that's accountable. I think by giving it to someone else, you're not really absolving yourself of that. If that's right, Patrick.
I actually also think this is a watch this space one, because right now, I think it just started last week, Microsoft has gone back against the US government to protest against requesting, Outlook.com, it's an online mail service, but they're actually now fighting, and they've just been backed by, it's now jointly Microsoft, Google, Apple, and a few others, objecting against the US government's request to ask for emails that sit on Microsoft servers based in the EU. Right, and they've just started fighting that in court now. So it'll be interesting to see how that, because that's a perfect example of that, is Microsoft had full control of that, right? In the US, they're a US-based company, they've got full control of that. But they're actually saying the way their servers are provisioned is that those servers in the EU house EU data and should be managed them under the EU laws of privacy, not what the US wants. So I don't know where that'll go, but I think that's if you want to Google and watch that, I think that may be an interesting space to see how that plays out.
Okay, no problem. So whilst you've got the microphone, Sean, I think in terms of like these kind of things, policies and enforcement, what do you see? In terms of how technology is going to assist people with this? Do you envisage people using techniques to monitor, like basically the outflow of their information? What information does get stored in certain countries? Are you going to start putting like automation in to raise alarms when stuff is? Are you going to block that information from being transported? What is the kind of feedback you're getting from your customers and how they're going to manage this?
Yeah, so I think when you look at all these things, it goes down to people, policy, technology is the order that we talk about it with our customers, right? Yeah. So technology plays an important place to do exactly the things you said. There's once you understand what your policy is, what you want to protect, what you want to monitor, behaviours you want to see, yeah, it's then that technology that automate all that process for you. So when you look at things like data breach, potential data breaches, it's important for organisations to understand, if we lose information, do we actually know whose information it was? We had a really great example where we worked with a customer where we placed technology in place that actually monitored the outbound movement of information, records, names and addresses. They had a data breach. They thought that they would have to reach out to 4,500 customers and advise them of that data breach. But through the use of technology, they actually realised there was only 700 and something people's names and addresses that actually met the requirements to say, hey, we should talk to these customers. And that saved them a lot of money, right? Yep. And so technology does play a role in some of those things to automate that, and actually understanding the context of what information flows around is an important part. But you've got to get the who's involved and the policies right, and technology is an enabler of all those things.
So
can I just put a little bit of meat around that? We've acted on a number of data breaches, and our experience is consistent with what Sean's describing in terms of it's often the small player that's caused the breach, and it has ramifications for their customers and their suppliers. But I just thought maybe it's not helping the audience so much to talk about being prepared and having a policy. It sounds kind of a bit like a platitude. I mean, it really is absolutely necessary that you have some kind of forensic guy look at your system and decide which log files are turned on, so that you can know what's being captured as to what's gone and where it's gone, and you also know what overriding to stop the minute there's a breach. It's absolutely critical that you know, you can assess whether or not you're going to go to the CEO straight away, and that you stop people talking before you know what has happened and where it's gone. As Sean was saying, a lot of these breaches are found 6 weeks to 6 months after they've occurred, and all you can see is an open window. You don't really know what people got, and you can't really work out what you need to say in response to that. So apart from the forensics and the issues management and working out who you're going to do in who you're going to tell in the organisation, and also the points of contact with the customer and how you're going to control that, it is really important to understand actually what information is where, and so you can also evaluate what's gone. So there is some real meat in this, in people telling you need to have a policy, you need to anticipate. The other thing I want to say about that is that people, I think, in an abstract level and from the lawyer's point of view, we haven't really fully thought through either all the obligations you ought to have in your agreements to deal with security, or all the places where your network has vulnerability. And while we're talking about the cloud, remember we started by talking about how if you outsource systems, you've got obligations to who accesses and uses your information. Now, most organisations have a lot of business process outsourcing. They have call centres, and so they have, at a business level, lots of access to data and lots of agreements dealing with that, which are not necessarily up to date with Australian privacy obligations and with access and control obligations. But then you also have a technical layer of access, right? You've got the second and third level software support, and people going into the systems to do updates and patches, and you've got people supporting your hardware. Now, sometimes the hardware is offshore in a data centre, but sometimes it's local, and it's just the database administrator who's following the sun with HP or with IBM, and lots of different people are getting access. And so you have to look at all those agreements as well and see whether you've got your security obligations in place. And then when you look at the security obligations, have you just got something bland, you will keep my information secure at an appropriate level, or have you got, you're going to follow 27001 and meet a basic IT standard, or have you got, okay, I've thought about it, this requires physical security, this requires control of our HR and training, this requires network security, this requires workflow in terms of what people can access for their tasks and when they get disconnected. And so there's lots of detail in terms of particular places and particular forms of access that really ought to be thought about and particularised. And at the moment, you often see agreements where it's a confidentiality clause and a privacy clause, and people think they've dealt with security, and they really haven't at all.
So Marco, I mean, you've got a lot of these things already in the cloud. I mean, your lifeblood systems, your core systems for your business. I mean, these essentially, no longer systems that you directly manage, right? Compared to an on-premise system, you've got full control over the operating system and so forth. I mean, are you finding that the level of logging and monitoring provided by the cloud vendors is sufficient, or do you somehow need to put a framework around all of these systems which are essentially not under your direct management? How do you do this, and do you need to kind of have ways to satisfy auditors and so forth? I mean, how do you approach this?
Okay, I suppose we have to take a practical approach, as does any business, and I think it'd be fair to say if we take a certain approach, we're not going to be expected to be able to put in the same processes and systems, say, as a government security organisation. I mean, that's obvious. We're a business of a certain size. We have to make sure that we take reasonable steps, and I know that goes in the courts as to what's reasonable and not, but being a law firm, we have a security sort of senior security partner or privacy partner who advises. It's not me making decisions, obviously. So we take reasonable steps, and I think that's the starting point. Yes, no, we can't log absolutely everything, check absolutely everything, and we take reasonable steps along the way. Doing some due diligence, again, I'll use the document management system, NetDocuments, as an example. The fact that there's 1,400 other law firms already using it, firms much larger than us, there's a certain amount of, I suppose, comfort in that they have also done their due diligence. And again, we went back to reputations and the like. It is critical for organisations like that to make sure they maintain the security and the privacy and all the things that you talk about. Yes, they will have the armed guards, they will have all of the systems for the physical monitoring systems, they will have their own logging and the likes. To answer, no, we have not gone in and sort of looked at the logs. We're not capable, we're too small to actually analyse those logs. Yeah. Internally, I mean, again, yes, we have certain systems. I don't go into the details of what we do, but an organisation our size quite frankly, can only do so much. I need to employ a team of security experts, bigger than my entire my IT team. It's just not practical. Yeah. So I think that's where it came for me. Is you do look at it. We're in business. You have to look at the practical side of things, but you clearly have to understand and you get advice from the right sort of people to make sure that you are doing what is reasonable.
Yeah, absolutely. I think this is really coming down to the same thing, where regardless of whether you're talking about security or even the service which you're actually taking from the cloud. I mean, I think it's all about kind of core competencies. So I think as a law firm, you want to focus on advising your customers and representing your customers. I think as a security firm like Symantec, I mean, they're going to be there providing monitoring capabilities to say, well, look, you let us look at your systems and we'll kind of tell you where we see unusual activities, who's been breached, and so forth. And likewise, the cloud providers themselves, they're going to be saying, well, look, we're the most qualified people to manage these systems, and we'll take care of all the patching and stuff. Which, again, as any organisation, they're going to be months, if not years, behind on patching and leaving themselves open to vulnerabilities. And I think, again, this is really coming down to the kind of, how does your risk profile change as things move into the cloud? So if you kind of start to look around, well, what are some of the causes of breaches? Is it through directly someone penetrating your firewall and hitting your system, or is it through compromising a person inside the organization? I think these are kind of, Alison, you guess with what you're doing, do you see this? People have this confidence in the people that you've got, and that's kind of, I guess, from my perspective, if I was looking at an organization, if you feel confident that the people you're engaging with are going to handle your data correctly, this is actually going to be a plus, right? It's just a lot more than just I tick these boxes and these are the platforms I provide. It's more around the the people and the process that you have to protect that information. Yeah, and I think
it comes back to what everybody's been saying, is that firstly, the fact that it's been utilised now for quite some time, that it's not just one or two organisations that are using the system, but several, and that that breeds a certain level of comfort. And at the end of the day, it's if there is a breach, it's your reputation on the line. But I think we probably need
I think we're just about on time now.
To wrap up. So.
Is there any questions from the audience? I think we're probably just about on time now. So I'd like to kind of wrap this up and thank everybody for their attention and questions during this session. I hope you found it beneficial. I think we'll all be around afterwards if you would like to come and talk to us and find out more about any of the topics we've covered today. So I'd like to thank all of our panelists for their time and contribution to today's session. So thank you very much. I think it's time for a break now. Thank you.